Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be Tenant Misconduct, Unveiling the Harassment. Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. Well, if you were listening to this broadcast live, the name of the song was Goodbye Yellow Brick Road. It was written by Elton John, but performed by Angelina Jordan, who was featured on America's Got Talent on February 7th of 2020. She came in second on that show, but it really literally launched her career and is certainly one of the most beautiful renditions of that song. I have an announcement. And that is May 20th, this coming Tuesday, there is going to be an apartment trade show. It's called the Income Property Management Expo. It's going to be held at the Pasadena Convention Center, sponsored by the Apartment Association of Greater Los Angeles. Come on down for the whole day. Admission, free. You got to pay for the parking, but admission is free. You're going to hear a bunch of lecturers. And also you'll see all the exhibitors, which will teach you how to operate your building more efficiently and, quite frankly, gain more wealth. I personally will be speaking at 1 p.m., so please come on down. I have a booth there as well, and you can ask me questions in the booth, and we're going to have some great handouts. And if you want, you can even take a selfie with me. But at 1 o'clock, I will be doing the seminar. The seminar is going to be dealing with new laws and avoiding nightmare tenants. New laws and avoiding nightmare tenants. Okay, let's talk about our show format, and that is I usually open it up to a topic, and then we'll open it up to those people who are either watching on YouTube Live or watching in the Zoom meeting. If you are in the Zoom meeting, towards the end of the show, we'll be allowing you to ask questions, and we're happy to answer those questions for you. If you do want to talk to me, please electronically raise your hand if you're in the Zoom meeting. I do take them in the order upon which they were received. And a little secret is I usually open up these meetings about 5, 6, 7 minutes before 3 p.m. So if you want to get called on, you can get in a little earlier. You'll also be able to hear the song, and you can electronically raise your hand so that you know that you'll have the best chance that I will be calling you. Okay, what is the topic for today? The topic for today is tenant misconduct, unveiling the harassment. Now, we all know that there have been a number of statutes regarding anti-tenant harassment protection. Well, I propose that there should be an equal number of statutes regarding anti-landlord harassment protection. The abuse created by tenants far exceed any abuse attributable by landlords. Now, there is a misconception in our law and by our citizens that people who own real estate need no protection. Nothing could be further from the truth. We need laws that are equally enforced. If a landlord fails to provide heating and was given a chance to fix it, the outcome of that is that he can be referred to the city attorney's office for criminal prosecution. Well, the same should be true for tenants who damage property, which costs thousands and thousands of dollars in damage. And right now I want to open up on my screen and I want to show you some actual pictures from my clients and what they had to deal with. And let me open up the screen here. And there we go. This is a kitchen scene by one of my clients. When he came in after we did the tenant eviction, you can just imagine the cost of putting this property back to its original condition. This is a story that's played every single day. I'm going to show you another one here. And again, some of these pictures are pretty gross. This is that same tenant's toilet. Again, can you imagine after you evicted the tenant for failing to pay rent, this is what you had to deal with, and how much money did that cost you? But it's just not tenants who just have no cleanliness habits. I'm going to show you some more here. And unfortunately, some of them are going to get quite grotesque. Here is a typical house where the tenant got mad at the landlord, of course, and decided that he would do his own artistry on the wall. And that's what we see now. But it even gets worse. Some of these tenants are incredibly vindictive. And as you can see here, this was a tenant who got evicted. He's claiming there that he's going to have to live in a tent. And of course, because he didn't pay the rent, all of a sudden, this is the landlord's fault. Okay. So this is what landlords have to deal with in terms of abuse on their property. And we want to see that there's equal treatment in the law. So is there a law that's in existence? Well, yes, there is. Let's get to Penal Code section 594. Let's read that. Every person who maliciously commits any of the following acts with regard to any real or personal property is guilty of vandalism. That is, if he defaces the property with graffiti or other inscribed material, he damages the property, or he destroys the property. In that situation, if the damage is more than $400, and of course it always is, vandalism is punishable by imprisonment in county jail not exceeding 1 year, or by a fine of not more than $10,000, or if the amount of damage is more than $10,000, then the fine could be up to $50,000 with that fine and imprisonment. So this is what we have to deal with regard to the distribution of the law in terms of what's put about for tenants versus what's put about for landlords. We want these laws enforced. Landlords who suffer this financial abuse should not have the law turn a deaf ear. The police in these circumstances will not even take a report. Yet landlords can be subject to civil and criminal penalties for failing to keep up the premises or from baseless accusations of harassments by tenant. Then there's an immediate and swift enforcement by the law, but certainly not in reverse when it's the tenant who's creating these types of situations, which are much more dramatic than whatever the landlord is doing. And in fact, in talking about tenant harassment, it was reported in the LA Times that from the years 2021 to 2024, there were 16,000 complaints by tenants to the Los Angeles Housing Department relating to tenant harassment. But the city attorney's office only found that 4 were legitimate, 4 out of 16,000. I can't tell you the amount of damage and destruction that landlords have to face. And it's just as if the law doesn't care at all. It's just like those days when people would walk into convenience stores and steal merchandise, or walk into department stores and no one cared. Well, the law should change, not just for retailers, but also for landlords as well. And it doesn't just stop at damage to the property. There's other types of tenant harassments. For example, it's common for tenants to make false claims to building and safety departments as to the condition of their property. And these false claims exist even though nothing's wrong with the premises, or, which happens in a lot of cases, the landlord was never informed. So the tenant doesn't inform the landlord that there's a problem, but immediately goes to the building and safety or the Los Angeles Housing Department, for example, and makes a complaint where the landlord has no clue. Also, in some of these cases, it's the tenants that intentionally cause the damage, and then they report this to the health department. This is also a common ploy by tenants' attorneys. And of course, if the building and safety comes out, the landlord is charged an inspection fee. and yet the landlord was never told about it. Now, if it turns out that these reports to these governmental agencies were false, then it's fair that the tenant should be subjected to fines and misdemeanor charges. That's fair. You make a false police report, that's a crime. And this should be a crime too. Also, we see that in lawsuits in court, that tenants just commit perjury, or in their documents to the court, their answer to the court, they claim all these things are true, but the truth of the matter is they're not. Let me share my screen once again. And you're going to see this is a typical answer that we receive when the tenant is contesting the proceedings. And all these boxes are checked. This is a typical answer, from infestation of cockroaches, that inadequate security locks, holes in the walls, etc. Well, when the case is finally heard, these things are not true. Now, when the tenant signs their answer to contest the proceedings, they're doing it under the penalty of perjury. When they go into court, they're sworn an oath under the penalty of perjury. Well, I think it would be fair that if, in fact, they commit perjury, that they're charged with a crime, because that is a crime. And this is what we're asking for: equal treatment under the law. Then we have other types of abuse by tenants against landlords. And these are the serial tenants who have been evicted multiple times with no intention of paying the rent. Now, this crosses over the border and should be considered theft of services. Again, these types of tenants who do this over and over again should be referred to criminal prosecution. And it's just as if someone's passing a check time and time again to a retailer. This is the same thing. A tenant goes in, has no intent of paying the rent. Landlord has to go through months and months of eviction. And yet this tenant has been evicted many times. And of course, under the crazy California state law, landlords can't effectively check to see if this person's been evicted before. Now, in some true abuse cases, the tenant gains entrance to the property by giving a check that's on a closed account. Well, this is purely criminal, and this tenant needs to be charged with a crime. You can't get even a police officer to take a report. Then you have cases where tenants just break into vacant units, or persons break into vacant units. And again, this should be a charge of trespass, but we don't see any of this. And last but not least, the worst is where tenants are either have threatening behavior or battery upon either residents on the property, landlords, managers, or workmen. And this should be criminally prosecuted. If somebody's threatening somebody, if somebody assaults somebody, just because you happen to be a tenant, it's fair that this person be charged with criminal prosecution. And that's why I call upon Los Angeles County District Attorney Nathan Hochman and the City Attorney Heidi Feinstein Soto to vigorously prosecute these cases. I also call upon the Los Angeles Housing Department to allow landlords to file complaints against tenants in the same manner that they allow a tenant to file a complaint against a landlord. Why shouldn't landlords be allowed to file complaints against tenants? And then after the review, if it's a legitimate complaint by the landlord, then the Los Angeles Housing Department should refer these cases to the city attorney for prosecution. I'm only asking for fairness under the law. The ones who are truly suffering are landlords, the ones who are truly abused and are losing thousands and thousands of dollars based on the conduct of these tenants, and it needs to be addressed by the law. And with that, ladies and gentlemen, that concludes the topic of tenant misconduct, unveiling the harassment. We're now going to open it up to questions and answers. And we know the rules, that these answers are for informational purposes only and does not constitute legal advice. If you do want to talk to me and you are in the Zoom meeting, please electronically raise your hand. I take them in order, so whoever is first will be taken, so you'll get the best chance that I will call on you during the show. Of course, the questions asked are for general legal questions only. And if you have a case with my office, please call my office to discuss that because we only talk about general legal questions. And if you are talking to me, please leave your camera on. Don't be shy because it does make it much more enjoyable for myself and for the audience. And last, if you guys are in YouTube, I'd appreciate it if you could click that like button and, of course, subscribe to my channel. And with that, we're going to open it up to our first caller, and that is Julia. Jordan, how are you?
I'm fine, Dennis. How are you today?
I am very good, thank you.
Okay, I have a question today. I've been getting requests for video ring doorbell cameras, and I just kind of want to know what the laws are and are not, or what we're allowed to do, not allowed to do, because I'm kind of at a loss as to really how to address this.
We have evicted tenants who put up Ring doorbells um, because it's a violation of the rental agreement because they didn't first get written permission from the landlord. But as a general rule, I'm a big fan of Ring doorbells. I've got two of them at my office, and I've got one at my home. And I just think it is a good way for tenants to understand that they're being watched. I don't think there's anything illegal about them. And this way, I think it provides for better security for your building. So if a tenant asks you, I would certainly allow that to be there because I just think that it's great security.
Okay, and on that note, the issue in my particular, one of my cases is where the doorbell would have to be placed would have the camera looking directly at their neighbor, almost inside of their neighbor's next door. And
Right. I agree with you that it should be, well, it should be so that, the person can see who's coming to their front door, but it shouldn't be intrusive where the angle of that camera can actually see inside another person's unit.
right, right. And so that's kind of the conflict that I'm having and why I said no. But I just wanted to make sure I was within my rights.
Right. I think you can angle that camera so it's not facing the other tenant's door, depending on what side of the door you're facing it on. And also, they have it where it actually, you can mount it at an angle. So you'll see the side of someone that's coming to your property, someone's coming to your door, you'll see their profile as opposed to face on. I think that would solve the problem.
Okay, so if the tenant that doesn't have the Ring doorbell, their guest would just maybe be videoed from waist down or something, and that shouldn't be an issue, as long as it's not facial
No,
recognition.
no, and you can take someone's face. I don't have a problem with that. I have a problem if the camera is facing into the other tenant's door
Well, that's what I'm saying. It's
window.
it's facing right into their front door, so it's going to get not only in their unit, but it's also going to get face
Yeah,
of their.
but again, if you have the camera facing at an angle, the way you're installing the Ring doorbell, you could make it so that it's only going to pick up people that are coming to your door, as opposed to your tenant looking inside your tenant's doors.
Okay, okay. All right, appreciate it. Thank you.
And thank you, young lady. Jim Polina, how are you on a Saturday?
Hey, Dennis. You got me rehabbing a house here. Couple questions. One is, as we advertise for new tenants, I found myself asking this question. I wasn't sure if I was blowing it. I said, what is your source of income? Is that a not allowed question?
You can certainly, you can't discriminate on the source of income, but you can certainly ask for the source of income. You got to know where they work and how they're getting paid. But for example, what the law talks about with the source of income that they say it's discriminatory is, for example, if you are getting, let's say, alimony, and you're saying, no, that's not a good source of income. Well, you can't say that
Okay.
because you can't discriminate on the source of income, but you can certainly ask where your income is coming from.
Okay. Second question now. in the lease, it says like 3 different areas. If there's any water leak or intrusion, any damage, contact the landlord. 3 places in bold. And anyway, we have a situation here. I'm going to reverse the camera so you can see out here. This is the front door.
Mm-hmm.
And what's happening is, see here, this sprinkler head come on and hit this wood here and hit the front of the door. We had all this damage from the water. Is that a tenant responsibility?
I have a phrase in my rental agreement that says that if the tenant is aware that there's a condition on the property, not necessarily caused by him, that is damaging the property, that the tenant has an obligation to inform the landlord. And to the extent that the damage is exceeded because of the failure to report, then the tenant would be responsible. I have that in my rental agreement, but quite frankly, I don't know how it would be enforced in that situation.
Really?
Yep.
Okay, so something obvious where the water is causing damage, but the tenant is obviously aware of it. It had to be going on for like a year. Not enforceable.
Well, I think it's questionable whether it's enforceable by the terms of the contract that is contained in my contract, which, by the way, is free and is on my website at evict123.com in the free form section. I do have that phrase in there, and you could try to, for example, deduct it from their security deposit in that if you had told me in the first week, there would have been X amount of damage, but 1 year later, I had to replace the whole door frame, for example, because you never told me. But of course, the tenant's going to try to claim that, hey, I never saw it, or something to that effect.
Right, right. And landlords always lose in small claims court.
It does tend to happen that way.
Okay, thank you, Dennis.
Okay, we're moving on to Andrea G. I'm going to ask you to unmute yourself.
Hello.
Hi.
Well, I will try to keep it short. What are the statute of limitations on suing your HOA for damages, such as mold, water? Is there
Well, generally, it's the HOA is there pursuant to a contract, your HOA agreement. So on a contract, it's 4 years.
4 years?
Mm-hmm.
Okay. And do you see any downfall if they are making some, trying to make amends for the damages caused if I was to use it against, let's say, special assessments or anything like that?
Again, it's a little off topic because we deal with landlord-tenant questions here, but let's pretend that the homeowners association had an obligation to fix a roof, which usually is what the cause is, and
Right.
that caused damage, and then you literally had to have a tenant moved out because month after month went by and they just couldn't.
4 months, yes.
Yep. See, I already know the situation. So would they be liable for the loss of income? And I think so. And so you could get a judgment against them, and then
Okay.
you could withhold your HOA payments until it's paid off.
Oh my God. Okay, I've got one more though. This was an Orange County situation. And of course, the tenant has already since moved out, but now they are contesting how much, of course, the damages were. That inhabitable sometimes, I can't even say the word, sometimes, but they cause damage to the flooring. And of course, they want their money back.
Well, uninhabitability has nothing to do with the equation. When you're talking about a security deposit, you're talking about, did the tenants commit unusual wear and tear? To the extent that they did, then they are liable for the repairs to that damage if it's unusual wear and tear. The question is, was that unusual wear and tear?
Blue paint and very large rust stains, larger than your hand. So, okay, that was just, thank you. That's pretty much it. And thank you. I also wanted to thank you. I saw one of your videos before, And I asked the tenant to pay an extra deposit back during those COVID days. And it all worked out great. And we're making a lot more money on that unit now. So thank you very much.
Oh, my pleasure. We are moving on to Harold. How are you?
I am good. I don't know if you can see me.
I don't think so. Are you there, Harold? I unmuted you again. Try it again.
Can you hear me now?
Now I can.
Does it look like I'm on Mars, or does it look like I'm on a news show?
No, it actually looks like you're on the space station looking down at Earth.
All right. Okay. So remember last week I was talking to you about this lady. They were going to offer money to move out. And what I found out is sometimes when you deal with these investors, they want to do a payoff. It's kind of like there's no accountability. So what I was thinking of, if they really want to get serious about making a payoff, they should have it put it in escrow instructions for this tenant, but have the people that actually own the property on the escrow instructions with the investor, since the investor is not the owner at the time. You know what I mean? Have everybody on the.
Generally, they do a voluntary vacate agreement or a cash for keys. Obviously, if I'm an investor and I don't own the property yet, I'm going to have a phrase in there that says that this agreement is conditional upon me becoming the owner of the property. Then in the terms of the agreement, it should state when the tenant is supposed to get the money. Do they get the money upon the execution of the agreement? Do they get the money half now, half on exit? Or do they get it all upon exit? So these are the terms that need to be negotiated with the person.
And then it's put it in an escrow, and we set up an escrow to make sure that we get the money, or you don't need to do that.
Well, if the tenant's going to get paid all at the time of the initiation of the contract, then you don't need an escrow because she's going to have the money in her hand.
Right. But if they're saying we'll pay half now and pay, when you look at the contract isn't even enforceable until they sign the last signature. So like the contract isn't even filled out completely.
That is correct. And in the city of Los Angeles, for example, there's what they call a 30-day cooling off period. So even if everybody signs it, a tenant can then withdraw as long as it's within the first 30 days.
I guess my question is she protected even if they try to screw her?
I think she's protected. Number one, she doesn't move until she has the money in her hand. So that's the protection that she needs. It's usually not the landlord who's going to create the problem on these cash for keys. It's usually the tenant who changes their mind or grabs some money and then doesn't want to leave.
Okay.
Anyway,
So
thank you
let's
very
say
much.
you got it. Thank you.
Okay, we're moving on to Sonia. How are you?
Hi, Dennis. Good. Thank you so much. Couple quick questions. The security deposit, once we return it, so can you clarify, does the tenant have to receive it by the 21st date? Just because in case we're mailing it on the 19th, they moved out of state. So
You mail it on within the 21 days is all the law requires,
okay, great.
even if they get it afterwards.
Okay, perfect. And then on the itemization form at the bottom where it has the owner's name and date, is it okay to type it in, or do they need a wet signature?
No, there is no signature at all required. You can print the owner's name or type it in. There's no
Oh,
signature required on a security deposit itemization. Once again, that form is on my website at
yes.
evict123.com.
Okay, perfect. Thank you so much.
And thank you. Good questions. We're moving on to Eric Chavez. How are you? Eric Chavez, I'm going to ask you to unmute yourself.
Hey Dennis, sorry about that. So my question is regarding when you have a tenant that when we talk about these habitable claims, bed bugs, they brought the bed bugs in. How can a landlord go about to make it ironclad? They can't sue us.
Well, you really can't, and I'm presume that if you picked up a bed bug, I would think you would see the tenant's name on that bed bug. So on that basis, it's almost impossible to prove that's the tenants who brought it in, even though we know the tenants brought it in. But bed bugs can go from one unit to another unit and basically invade your whole property. So I don't think that there's any way to avoid liability on that kind of situation. However, there is, and I have it on my website, a bed bug addendum, which tells the tenant that they have to immediately inform you if there is a problem. And then if you are informed, I'd get yourself a qualified pest control company who deals with bed bugs to eradicate that problem. And that bed bug addendum should also state on it that the tenant has to follow the instructions of the pest control company by removing their clothing, etc., and maybe having it dry cleaned.
And okay, so even when using that addendum, but you treat you as a landlord, you're responsible, but you still get hit with the lawsuit. So there's nothing we can do to protect ourselves to say, hey, here's the proof. We responded, we treated, and we still get hit with the lawsuit. So you're telling me there's nothing we can do.
Anybody can sue anybody at any time, but based on the fact that you had a bed bug addendum to the rental agreement, that upon notice you immediately took action, I don't see that would be a good lawsuit to be brought. So on that basis, I don't think you'd be sued.
Well, I got hit with one, and so
Well,
now we find out. So like it's one of the ADA drive-by lawsuits. They're going to get a minimum is $60,000 per tenant. Here's 5, so they're going to get $300,000 from the insurance company.
it is insane. This is the new thing. We see all these ads on TV for personal injury attorney. Have you been involved in an accident? Call us. If you weren't at fault, call us. We can get you much more money than the insurance company. Well, there's a new game in town, and that is suing landlords for habitability claims.
Yeah.
And they're going after landlords. One of my clients called me this week and said that all of her tenants got solicited by a law firm saying, hey, your landlord not taking care of you, we can sue your landlord. Now, the way she got this was there was a vacant unit. So it came in that vacant unit mailbox. So of course, she opened it up and saw that they're soliciting tenants. So, and I've had shows on this. You can go back and listen to other videos, but obviously you want to make sure that tenants have to, and this is a form again on my website, that they have to inform you of a problem in writing. And if he does inform you of a problem in writing, you want to immediately go over there and you want to correct it. You want to send a follow-up letter to the tenant that you called me on Tuesday. I was there on Wednesday, problem solved. And do this. This is the best ammunition that you have, other than having a great insurance policy, to prevent these habitability claims.
I got it. Thank you.
And thank you, Eric. Arlene, how are you?
Hi, Dennis. Happy Saturday.
Happy Saturday.
Thanks for all you do. We really appreciate it. I just wanted to give you kind of an update on your forms area.
I think you hit your mute button. I just allowed you to unmute yourself.
Sorry.
Yes, go ahead.
The form that you have to post on your RSO or any property that you need to post that was updated in October of last year has now been updated. There's a new one in March.
Yes, I know that. We've been meaning to change that. In fact, I already have that with my webmaster to change that.
Oh, okay. I just have one quick question. I got a call this morning from Tenant letting me know that their dog bit the dog house watcher, or the person watching their house while they were away. So they need to contact their renter's insurance. Do I have liability as well? Do I need to contact my insurance?
Okay, so in other words, your tenants were away. They hired a house sitter to watch their dog, and obviously he got a little too close because the dog bit the house. I don't think you have any liability at all, but now that you know that dog has a propensity to bite, you need to tell that tenant that they should get rid of the dog at this point, because the next time, if that dog bites, let's say somebody in the common areas, you would be held responsible because you now know that the dog has this propensity to bite. Yep.
Okay, thank you.
And thank you. Good questions. Martin Adler, how are you on a Saturday? Martin Adler.
Okay, I hit the unmute. There we go. Dennis, somebody wants to move in with a comfort animal. What and where can I find the latest laws regarding what can be a qualified expert to say the person has the need of a comfort animal?
If you want to know the exact requirements under California law, if you do go to my website, evict123.com, this one's in the legal issues section. Look for that and scroll down, you'll see that. But generally, it's any medical professional, that's the way it works, who's licensed in the state of California. So if they bring you a letter from a medical professional licensed in the state of California, and it states that your tenant has a disability, they don't have to describe it, and would need the services of a comfort animal, then you have to allow that animal in. The tenant has to have treated with that medical professional for at least 30 days prior to the professional issuing that letter.
Okay, thanks. And one other thing, I was going to call into the office during the week. I can't get insurance, so I think I want to put the property finally into an LLC. Would they be able to help me with that, or is that a different type of attorney?
No, we specialize in doing LLC. So just call the office, and one of my expert attorneys, and I'll even tell you what her name is Madison Block. Now, very coincidental that she has the same last name as me, but of course, that's my beautiful daughter.
Right. You mentioned her many times. All right, thanks. I'll call into the office. Thanks.
Thank you, Martin. Moving along to Mike Nugent. How are you? If you could unmute yourself, Mike. Okay. Last chance. Okay, we're going to move on to Gid Martin. I'm going to ask you to unmute yourself.
Hey, Dennis, how you doing?
I'm good, thank you.
Good. Thank you for your service, and sorry about your Lakers. I'm not sure if Reddick is the answer, but anyway, we'll move on. I'm actually putting my condo back on the market. I took it off the market because I was going to sell it. It fell out of escrow. I'm going to put it back on the market. And I'm wondering if I'm subject to RSO. Do I have to let them know? Oh, and if you could please answer that question earlier. I missed part of it. It was about how to avoid a habitability lawsuit. I know you said a strong insurance policy, but also you said something else as well, and I missed it.
Well, with regard to trying to avoid habitability lawsuits, make it a condition of the tenancy that the all repair requests, except for emergencies, have to be put in writing. And as soon as the tenant does give you something in writing, then you document how fast it took you to correct it. So if they said there's a problem with the plumbing, or if there's roaches, you want to have a roach company there, the following pest control company there the following day. You want to have the plumber there. You want to do a follow-up letter saying, hey, you contacted me on Tuesday. I had the problem resolved on Wednesday. Thank you for keeping me informed. That's the best way to handle it in addition to the insurance. With regard to your condo is located in the city of Los Angeles?
Yes, it is.
Okay, so condos can be subject to the rent stabilization ordinance if the condo was built prior to October 1st, 1978. Was it?
Yes.
Okay, so you do need to register that unit with rent control. You have to pay their yearly fee on that. However, you are not subject to rent limitations. So if you rent that unit out on a month-to-month basis, and then 6 months later you want to raise the rent to another level, you have the right to do so.
Okay, so no rent limitation. I was thinking about that also. So when I put it back on the market, I can put it back on the market at the current market rate.
Absolutely, and you definitely should.
Okay, and I can raise rent at whatever rate I deem, as long as I give a 60-day notice.
Yeah, whenever you like, as much as you like.
Okay. Okay, thanks.
All right. I like JJ Redick, but I think he did a good job. But we didn't have a center, so that killed us on that last game. Moving on to Veronica Garcia. How are you?
Hello, Dennis. Hello, Dennis. Thank you for your time and answering my question in advance. I have a question regarding inherited tenants in the LA County. Do we rewrite similar agreements they had with the last landlord? If otherwise, can we reinforce less parking spots or eliminate the usage of laundry machines in the premises due to having rents under market value?
Okay, well, first of all, you said this is an unincorporated area of LA County?
That is correct. Yeah.
Okay, so you're under their rent control, LA County rent control, and you can't force a tenant to sign a new rental agreement. Okay.
Mhm.
You can take away, for example, parking, but you'd have to give them a corresponding decrease in rent. And that would be determined potentially by the county rent control board. Obviously you can't have them force them to sign a new rental agreement, and obviously you're subject to their rent limitations based on what they're allowing for rent this year.
All right. Thank you.
Thank you, Veronica. We are moving on to Mrs. Martha. How are you?
I'm good, Dennis. How about you?
I can't complain.
I just had a question regarding noise issues or noise violations. I have a couple of tenants that play loud music during regular hours before 10 p.m., but it is bothering other tenants. So any recommendations on how to write a letter or what could be done in regards to asking tenants to kind of keep noise at a I guess a normal level?
Well, the reality is that if you're in a car on a street and a car pulls up to you with his window down and he's blaring his music, guess what? It's annoying. And the fact that it's in the middle of the day doesn't change anything. Their tenants are entitled to peace and enjoyment of the property 24/7. That doesn't mean that there can't be more noise during the daytime, but certainly if it's exceeding a higher level and it's bothering other tenants, you should send immediately a letter to your tenant warning them that this is becoming a nuisance and that other tenants are complaining and this has to stop. Otherwise, you're going to bring forth an eviction.
Okay, thank you, Dennis. I appreciate that.
Okay. Lynette Austin, how are you?
Doing good. I had a eviction. The person's out. What is the statute to sue them for damages? Is it
Well,
you?
I would think it's 4 years because I presume they signed a contract. And in that contract, I'm sure there's something that talks about that
And
you're responsible
Yeah,
for
there was
any
no
damage.
there was no contract because it was my caregiver's son who moved in.
Okay, if there's no contract, then you're looking at probably about 2 years.
Okay.
2 years.
And then my other question, because I missed civics class, if the board of supervisors for the county changes, can they go in and remove rent control if we get some of these people out?
Absolutely.
Okay.
And the county board of supervisors, which instituted rent control, just like all these other city councils, if they vote to get rid of it, then it's not there anymore. But the chances of that happening
It is, yeah, Neil.
slim to none.
Okay, thank you.
Okay, moving on to Salvador Calderon. How are you? Salvador Calderon.
Can you hear me? Can you hear me?
I can.
All right. No, this is Juan again. And I had a question. I built an ADU a couple years, 2 years ago in the back of the house. And then in the front of the house, my house was made in 1950. I'm going to have a boarding care here eventually, probably by next year. would I have to, because this house is 1950, it's in the unincorporated side of Whittier. It's in the city of Whittier. Do I have to pay for an RSO on that because it's a 1950 home? Because I'm going to be renting it to the company that I own. That was my question.
All residential units in unincorporated area of LA County need to be registered. So you're
But
going to
this
have
is
to.
this is not unincorporated. This is the city of Whittier. So
Oh, I'm sorry. I misunderstood then. Then no,
Sorry.
you don't have to register it. They don't have that. You're only under statewide rent control in that situation.
oh, okay.
You're good.
So I can raise it up to as much
You can
as
always raise it whether it's under rent control or not for any single family home, townhouse or condominium. There are no rent limitations, but sometimes you'll have limitations in terms of that you need to have good cause to evict. So for example, in that rental agreement that you signed with that person in the city of Whittier, hopefully you checked the box that said this property is exempt from statewide rent control in your rental agreement. If you did that, then you don't have to have any reason to ask this tenant to move when you want to change it over to a board and care facility, and you wouldn't have to pay any relocation at all.
Okay, thank you.
Okay, let's move on to Carrie. How are you?
Dennis. Hi, Dennis. Can you hear me?
I can.
Great. Thank you. I have a condo in the city of Los Angeles, and my question is, how do you deal with tenants that gave their 30-day notice that they're going to vacate, and they're supposed to be out by the end of this month? So June 1st would be their first day not there. But what happens if they're not done packing and moving their stuff? Does it become like a daily rent fee that I charge them?
They gave you I would certainly hold them for daily rent. You could make an argument that if they didn't move on May 31st, that they owe you for at least one more month's worth of rent. That's a reasonable argument.
Okay.
Probably a more practical way to do it would just be to charge them for the daily rate, and that would be about it.
Okay. Okay. But as far as that, I mean, do you have to serve them a formal letter?
No, when they do move out, you're just gonna, from their security deposit, you're gonna deduct another 5 days worth of rent.
Okay. Okay. Thank you.
All right. Let's see. Going back to Mike Wynn or Mike Nugian. Are you there? Can you unmute yourself? Okay, Mike. And how about one more caller? We're going to do Martin Adler. How are you, sir?
I am fine. Thanks, Dennis. A real quick question. I am going to be calling the office about LLCs. My quick question is, if I create an LLC, do I have to do all new rental agreements also in the name of the LLC?
The answer is no. You could if the tenants are willing to sign it, but in most cases they won't. But what you do have to do is you have to do a change of ownership, because by putting it into an LLC, the owner is now changed. That form, which is incredibly important to give to each of your tenant, is on my website in the free forms section. So please, as soon as you get that LLC, go to the website and just fill out that form. It's fillable on the website. Anyway, ladies and gentlemen, we have made it to the end of Zoom Landlord Tenant Talk Radio. I want to thank everybody for making the show for what it is by coming out. If you are in the YouTube meeting, please hit that like button and subscribe to my channel, because it really does help me. And once again, this Tuesday, May 20th, I'll be speaking at 1 p.m. This is at the Pasadena Convention Center. Admission is free. It's called the Income Property Management Expo. And come and hear me speak, and I'll be happy to talk to you personally in my booth and get my free handouts. With that, everybody, thank you very much for joining.